Good afternoon. My name is Malia Brink, and I am counsel for public defense at the ABA Standing Committee on Legal Aid and Indigent Defendants. Thank you all for being here today, and welcome to the latest webinar from the ABA section on civil rights and social justice, co-sponsored by SLADE and the section on criminal justice. If you like our work today, we hope you'll consider joining the ABA, and particularly the section on civil rights, social justice, or collaborate on some of the projects that we wish to develop. During today's program, just a couple of technical notes. If you look on the control panel, there's a drop-down portion for questions. You can type questions, and as the moderator, I'll be checking those and making notes to ask our panelists when they're done with their presentations. Also on that control panel, is a drop down for the handouts related to this webinar today. And you will also get a link afterwards with the ability to replay this session and see the handouts after the session is over. We're thrilled to bring you today's program entitled Bail Reform Litigation, Past, Present, and Future. Our panelists today, Alex Karakanis from the Civil Rights Corps was sadly detained and with travel plans, so Katherine Hubbard is joining us. She's an attorney with Civil Rights Corps, where her work focuses primarily on criminalization of poverty. And she was instrumental in the Humphrey litigation concerning bail practices in San Francisco. Also joining us today is Alex Shalom, who is a former public defender and senior supervising attorney at the ACLU of New Jersey, where he was involved in efforts both to achieve and protect bail reform. As I said, I'm going to be kind of monitoring for questions after they start their presentations. Our goals today are to kind of talk about bail reform, what's been successful, but also look at the aftermath of successful reform in terms of backlashes and protecting those reforms and how do we keep it going. And so with that, I'm going to turn it over to Katherine.
Great, thanks, Malia. And thank you for that introduction. As Malia said, I'm an attorney at Civil Rights Corps, and we, in the last 3 years, have been bringing litigation all around the country focused on reforming the current money bail practice. And I'd like to start out just by using the Humphrey case as an illustration. And as I just give a little background on that case, I'd just like to share a photo essay that was put together by a wonderful organization based in San Jose, California called Silicon Valley Debug. In honor of the Humphrey anniversary this year, they put together this photo essay that shows Mr. Humphrey and a day in court for him. So I'll just pull that up. All right, so to give background on Mr. Humphrey's case, Mr. Humphrey, at the time we filed a habeas petition on his behalf, was a 63-year-old man. He was living in a retirement community. He was accused of following a fellow resident of his retirement community into his apartment and stealing $5 and a bottle of cologne. Based on those allegations, he was arrested and charged with burglary and robbery, and his bail was set at $600,000. Sorry, just making sure the pictures are available. Okay, so yes, here's Mr. Humphrey and his partner, Judy. So as I said, his bail was set at $600,000. That was eventually released to $350,000, which was still far beyond his ability to pay. We, in partnership with the San Francisco Public Defender's Office, developed a program where we would file habeas petitions on behalf of people like Mr. Humphrey who had money bail set in an amount that they couldn't afford. And again, just clicking through these pictures just to show you a little bit about what Mr. Humphrey's life is like outside of court now. He's still awaiting trial, but is now free and is able to, attend his court appearances in civilian clothes rather than an orange jumpsuit. And here he is standing in front of the Hall of Justice in San Francisco. And with that, I will close out of the pictures and continue to just talk more about what actually happened in his case. Obviously, he is out now. But what happened was we brought a couple different claims on Mr. Humphrey's behalf. And those claims are two substantive claims and one procedural. So in our habeas petition to the Court of Appeal in California, our substantive claims were that Mr. Humphrey had two substantive rights that were being violated by his ongoing pretrial detention. And that was a right based in the equal protection and due process clauses, not to be jailed solely due to inability to pay. And that was based on the Bearden, Tate, Williams line of cases. And another substantive right to pretrial liberty. And that comes from Salerno is the case we rely on for that, which says that pretrial liberty is a fundamental right. And so this right against wealth-based detention and this right to pretrial liberty both require that before a court can detain a person pretrial, they need to make the substantive findings. They need to find whether detention is required and then make findings about the person's ability to pay. So what this comes down to is that a court can't just set money bail and hope the person can't pay it or hope they can and that they'll eventually get out. It means that a court that is setting money bail needs to start out by making the inquiry into whether the person actually needs to be detained. And this question can only be answered by undergoing an actual bail hearing. And so if the result of this hearing is that the court determines that the person doesn't need to be detained pretrial, then the court needs to set conditions of release that actually facilitate release. So if that's going to include a monetary condition of release, it needs to be set at an amount that the person can actually afford. If the court is going to detain the person, it can only do that after holding a hearing and then making findings that the person must be detained because there's no less restrictive alternative that can guarantee or reasonably guarantee the government's interests in court appearance and public safety. So, the court needs to make that substantive finding that no alternative can meet these compelling interests of the government. And that also leads to the procedural claim, which is that in this bail hearing, or this hearing where a person's pretrial liberty is being decided, certain procedural protections are required in order to ensure that the decision is correctly made. So some of those substantive guarantees or substantive requirements include notice of the purpose of the hearing and that at question will be the likelihood of appearance in court and the public safety. It requires the arrestee to be able to put on evidence and confront evidence against him. It requires a heightened evidentiary standard, the clear and convincing evidence standard. It requires a neutral decision maker and that decision maker make findings on the record of the person's either ability to pay the amount or that the person needs to be detained because no alternative condition of release will satisfy these government interests. So these were the claims that we brought on Mr. Humphrey's behalf, and the Court of Appeal ultimately agreed with all of those and issued the In re Humphrey opinion almost exactly a year ago. And that opinion just basically said all the things that I just said, that a court in setting bail needs to determine whether a person should be released. And if finding that the person should be released, can't set money bail in an amount that the person can't afford. And that the clear and convincing evidence standard applies when determining whether a person needs to be detained, and that these procedural safeguards also need to be in place. So that was a very exciting moment, but is obviously not the end of the story. So a lot's been happening in California since then. First of all, the Supreme Court of California is now reviewing Humphrey. And it's sort of an interesting situation where the issue that's really in contention in the Supreme Court is not one that was actually litigated in the lower courts, and that's about California's detention net. So basically, we're seeking to answer the question, in what cases can a person in California be detained pretrial? And in our opinion, it's a very narrow category of people charged with serious felonies where the court has made certain findings. And on the other side, the San Francisco district attorney, who is acting as the petitioner in the Supreme Court, is arguing that almost everyone can be detained as long as the judge makes these findings that the court in Humphrey said they have to make. So that question is up in the air right now, and will hopefully be decided later this year. And in the meantime, other things have been happening in California as well. Most importantly, the passage of SB 10, which completely overhauled the state's bail system in a way that unfortunately is not good. It does get rid of money bail, which is certainly a positive step, but there's a lot of concern that the system that it puts in place will actually result in even more pretrial detention. So that is currently, the bail bond industry has created a ballot initiative and or a petition to vote on that bill to repeal it in the 2020 election. They recently got that certified, so SB 10 won't be going into effect at least until 2020, if it does go into effect at all. But the Humphrey decision is going to be really important if SB 10 does end up going into effect, because it will determine who can be detained under SB 10's new system for pretrial detention. So, so Mr. Humphrey's case is ongoing, and it's interesting to see where things will go in California from here. So then the other area that Civil Rights Corps works on, in addition to these habeas cases, is our federal class action lawsuits. We have cases ongoing all over the country right now, and one I just wanted to focus on right now is the case in Harris County, Texas. That was a case that we originally filed back in 2015. And in that case, we brought a class action in federal court on behalf of a couple people who were in pretrial detention in Harris County, charged with misdemeanor offenses, who had gone through a bail hearing, which at that time basically looked like, and there are lots of videos online available if anyone's interested in seeing what it looked like, but looked like a video link from the jail to a courtroom. And people in the jail would stand in a red box and talk on a video camera to a judge. They were not represented by counsel at that hearing. They were typically not allowed to speak. And it would last less than 30 seconds. The judge would find probable cause in their case, set bail pursuant to a schedule, and that would be it. That would be the only opportunity for a lot of people charged with misdemeanors to really speak to a judge. And so we brought that class action, a class of all people charged with misdemeanors who were being held on money bail that they couldn't afford in Harris County. And that resulted in a preliminary injunction, a 193-page opinion striking down Harris County's misdemeanor bail system. And that resulted in more than 13,000 people charged with misdemeanors being released since that preliminary injunction was issued. The misdemeanor judges who were defendants in the lawsuit fought the case very hard and appealed twice to the Fifth Circuit. And it was looking like it was going to be a very long, drawn-out litigation. And that all changed last November when almost all of the misdemeanor judges were voted out of office and replaced by judges who had pledged not to continue to fight the lawsuit, who acknowledged that the misdemeanor bail system was detaining unnecessarily far too many people, and who wanted to reach a settlement on the case. So since then, it's been a real sea change, and the judges withdrew their appeal to the Fifth Circuit and recently issued a new rule on misdemeanor for misdemeanor arrestees that eliminates wealth-based detention and will result in the release of the vast majority of people charged with misdemeanor or arrested for misdemeanor offenses in Harris County. So that election really made a huge difference in the case. And the parties are now working on enshrining that rule in a settlement that can be enforced by the federal court. And then the latest development in Harris County a couple weeks ago, these principles about the right against wealth-based detention and the right to pretrial liberty is obviously not limited to people charged with misdemeanors. That is probably the easiest case to win, but the principle certainly applies to people charged with felonies as well. So a couple weeks ago, Civil Rights Corps, the Texas Civil Rights Project, and the law firm Sussman Godfrey, who has worked with us on the misdemeanor case as well, filed another lawsuit in Harris County, this time brought on behalf of a class of felony arrestees. And we are hopeful that we'll be able to resolve that litigation as well, and be able to get in place a settlement that completely ends wealth-based detention in Harris County. So with that, I will turn it over to Alex, and happy to talk more about these cases and CRC's many other cases around the country.
Great. Thanks, Catherine. Let me just get this going here. Okay, so first of all, sorry about my slide, which was made before we upgraded from Alec to Catherine. But here we are. This is me. If people have questions, and I'll have this slide again later if people have questions later. So New Jersey kind of took a different route. And so I want to just take a minute to spend some time talking about that route so you can see that there are other ways to get to the same place. So where Katherine is talking about bringing litigation to bring about change and then creating a system to fill the void created from the absence of the bad system, New Jersey first went through the legislative process, and then we've been using litigation for two reasons, which I'll talk about as we go through here. So really quick history of New Jersey. I know this is boring. I'll try and spice it up a little. But so going back to 2013, you had what we had everywhere, which is that wealth-based detention was really stupid and discriminatory. And so you had, rather than jails filled with dangerous people, you had jails filled with poor people. Those were predominantly people of color, and they were there for a really long time. And of course, as everyone knows, there were tremendous coercive effects that detention had in terms of pleading guilty, in terms of worse sentences after trial, more frequent guilty verdicts at trial. The DPA report, the Drug Policy Alliance report, really catalyzed a lot of action in 2014. The Chief Justice of our Supreme Court called together what he called a Joint Committee on Criminal Justice to propose tinkering with the bail system. The committee met and unanimously voted, and it was a really diverse committee of stakeholders ranging from the ACLU to the Attorney General, the public defender to the county prosecutors. Everyone agreed that there was no way to tinker with the system. The system had to be fundamentally reimagined. Simultaneously, there was a legislative push with lots of community support. We got a good law signed in August of 2014. Voters voted on a constitutional amendment in November of 2014, both August of 2014 and November of 2014. That meant that the law would go into effect on January 1, 2017. But before we got there, there were a couple challenges filed. And so let me talk about that. But everything here is kind of from January of 17 on. And so the two types of litigation I want to talk about are the litigation we did to protect the framework. The legislative framework that we created was challenged by a bunch of folks, mostly by the bail industry, but by others as well. And then also the framework to us was kind of the starting point, and we wanted to make sure that the protections that we all think are necessary to any system that involves pretrial detention of any sort, that the protections were as robust as possible, the detention net was as limited as possible, and frankly, the act of detention was as limited as possible, because the New Jersey statute is far from perfect. Among other things, it has a very broad net. And so our job through litigation was to minimize the number of people who are going to be detained. So quickly, I'll talk about protecting the framework. The first challenge we faced was in, I think, November of 16 or December of 16. It was a month or so before the statute was going to go into effect. We have a kind of bizarre system in New Jersey where when a state law mandates an expenditure by either a local municipality or a county or a school district, they can challenge it as what's called an unfunded mandate. And it's bizarre and kind of kangaroo courty, and it's decided by a panel of folks who are not necessarily lawyers and certainly not judges. And we actually beat back that challenge by one vote. We were lucky. Almost as soon as the law went into effect, the bail industry filed a challenge on behalf of Mr. Holland. Mr. Holland was charged in a bar fight. It was a very Jersey bar fight. It was, I think he was a Cowboys fan who allegedly beat up an Eagles fan, but it might have been the other way around. But it was a football-related fight. He was charged, and they moved for detention and then decided not to detain him, and he was released on GPS monitoring. And his lawsuit brought by the bail industry contended that he had a right to be released on money bail, even though they conceded he could have been detained to protect public safety. And so the Attorney General defended the law. A group of civil rights organizations, the Drug Policy Alliance, the NAACP, the Latino Action Network, and the ACLU appeared in support of the Attorney General, both at the district court level and at the Third Circuit. We won in both places. and then they petitioned to the United States Supreme Court and certiorari was denied. There have also been some other less serious challenges. The less serious ones were promoted by Dog the Bounty Hunter. I think that gives you a sense of the legal merits of the argument. But where we've devoted more time has not been to protecting the framework, but instead to giving meaning to these 5 kind of categories of protections: discovery, witnesses, presumptions, burdens, appeals. And I should note that had we been in a place where we had to seriously fight over the right to counsel, that would have been kind of primary, but no one on the prosecutor side or the defendant side ever contended that defendants weren't entitled to lawyers from beginning to end of this process. So I'm going to try not to bore you, and if I have to bore you, I'll do so with different masks on, by talking too much about the specifics, but I think it's important to know what exactly we've done through litigation. And so the first thing is discovery. And I think that's the first thing because anyone who litigates cases understands how important discovery is. And we had a statute that said that defendants were entitled to discovery before a detention hearing. And the real question was going to be, so what? What does it mean? What discovery? When? How robust? And so the very first case that the court heard on our new statute was just months after its inception. It was State versus Habib Robinson. And they really set the tone in Robinson for making protections meaningful. And so what the court decided after Robinson was that prior to a detention hearing, a defendant would be entitled to kind of the basic police reports, but then all statements and reports related to anything in the affidavit of probable cause. So if the affidavit of probable cause said there was an eyewitness identification, you got the statements and reports related to the identification. If it said we lifted a fingerprint, you got the reports and statements related to a fingerprint. So it was a lot of stuff. You also got anything that the state, if the state was going to argue that you were a flight risk or a particular danger to the community, you'd get any statements and reports related to that proffer that they were making. And you were also entitled to all exculpatory information. And this is, just to be clear, you get arrested and you'd have an initial appearance in 24 to 48 hours. At that time, the state would move for detention. And between 3 and 5 days later, you'd be having this detention hearing. And at that detention hearing, you would be getting that robust discovery. And so I know my colleagues who practice in federal court, my colleagues who practice in New York State, for example, you would be getting in New Jersey more discovery 5 days into the case than folks are getting oftentimes right before trial in other cases. So that was a really important case. We've had 2 other discovery-related cases that are on much smaller issues. Dickerson dealt with whether or not the defendant was entitled to the affidavit in support of a search warrant in a case where all the state was proceeding on was what they found as a result of the search warrant. We lost. The holding was you were entitled to the search warrant, but not the affidavit at this initial stage. And State v. Hippolyte was one we just argued and actually just got a decision on in December. The question there is, what is the remedy when a prosecutor fails to provide exculpatory information before the detention hearing? And the remedy that we advocated for and that the court basically adopted was an automatic reopening of the hearing. And so they didn't go quite to automatic, but the burden is on the state to show why such a reopening wouldn't be appropriate. Okay, moving past discovery, witnesses. I don't want you to think this is just like Alex bragging about the success of bail litigation in New Jersey, because here's a case that we lost very early on. The statute makes very clear that defendants have a right to cross-examine any witnesses that are called. And the question came up, okay, but does that mean, implicit in that, is there a requirement that the state call a witness? Or can they proceed using hearsay through proffers? And we argued there was an obligation, and the court said there's not an obligation. And let me just be totally honest, what that means is, in detention hearings in New Jersey, almost always the state is introducing information by proffer. There are not cops called, there are not victims called. Pinkston deals with maybe a corollary question, which is, okay, the state isn't calling the adverse witnesses, the complaining witnesses, the police officers, can the defendant? And in Pinkston, the court answered that question in the affirmative and said, yes, you might have to make a proffer, and we're not going to allow defendants to needlessly harass victims or police officers, but if they can make a proffer about why it's relevant to the determinations the court needs to make, namely that there's probable cause and also that detention is necessary, that there's no condition or series of conditions that will promote the purposes of the statute without detention, then this defendant may be permitted to call a witness. Presumptions, I think this is probably the most important part of the work we've done, and frankly, the most important part of the New Jersey statute, because if you look at the New Jersey statute, you'll see there's this really broad detention net, and almost everyone is eligible for detention. However, there are also these, I think, quite good presumptions against detention. So if you're charged with murder, or if you're charged with another crime that carries life in prison, there's a presumption that you will be detained. If you're charged with anything else, attempted murder, carjacking, robbery, rape, you name it, drugs, there's a presumption of release. So there's a broad presumption of release. And then the question was, okay, but what does it mean? And in State versus SN, and then really in State versus Travis, the court confronted it. And the way it came up was in these cases where defendants have not much criminal history to speak of. In fact, in both of these cases, they had no criminal history, but they're charged with incredibly serious offenses. So in SN, it's an aggravated sexual assault over a course of years. And in Travis, it was a robbery where the victim was shot. So we're talking about among the most serious offenses. And so our risk assessment tool recommended detention for both of these folks just on the basis of the crime charge, not based on criminal history, but based on the crime charge. And we had a court rule at the time that basically said the court could treat as prima facie evidence sufficient to overcome the presumption of release the recommendation from the risk assessment. And what that meant to us was that it rendered the presumption of release worthless, because great, you've got this presumption of release, but the mere recommendation from the risk assessment would be all the judge would need to find. And so we argued in Travis that that contradicted the purposes of the statute, which called for broad release, and the court agreed with us in Travis and rewrote the court rule that it had adopted just months before and said, listen, if we want to mean what we say about a presumption of release, the state's going to have to come forward with more than merely the person has been charged with a serious crime, unless it's one of the few crimes, murder and crimes that carry life, where there's a presumption of detention. So this is an area where, through our litigation, we really made sure that the protections that exist in the statute were meaningful, and it has really had an impact on the number of folks who are getting detained. Burdens of proof, pretty similar stuff, but in Mercedes, you had a defendant with a really serious criminal history, also charged with a really serious offense. He was charged with a road rage shooting, and his risk score came out very high, but the case was kind of a shitty case for the state. There were lots of reasons to believe that the state wasn't going to make its proofs. And so because there was this robust discovery that we'd gotten through the Robinson opinion, the defense attorney was able to stand up and say, yeah, they said they have a statement that ties him to the car, but in fact, look at what the actual statement says. He's not at all tied to the car, and so on and so forth. And the question in Mercedes was, okay, so can the trial court kind of take into account the strength of the case? And the court said, well, of course they can. They can take into account everything. It's not, we don't want judges to function like automatons. And when there are factors that militate against or for a particular decision, they should consider them. Last one that I'll point out, just because I've talked to some of my colleagues in other states, and I know that they've been so frustrated about bringing litigation in bail matters because of concerns of mootness. Right? Pretrial detention is necessarily so quick and so fluid that you're going to file a case, and by the time you make it up to the state Supreme Court or wherever it is you're going to bring the case, it's likely that your client will have pled out or have been released or whatever. And in Pinkston, which is the case I already mentioned, but the court really set the tone and said, listen, these are important cases of issues of great public importance, and we're going to excuse the traditional doctrine of mootness, and we're going to decide it anyway, both because it's capable of repetition and evading review, but also because it's an issue of great public importance. And I think the New Jersey Supreme Court's decision to do that has given us great latitude to really push on the contours of the statute to make sure it's as protective as possible. Okay, I want to just kind of quickly flag, since that's one of the things we were supposed to talk about, that this is where we've been so far, but it's certainly not where we're going to be forever. We anticipate there will be other challenges to be brought. People have, in the first couple years, been really excited to get out. And so they've accepted, oftentimes by consent, conditions of release that are too onerous, I think, to comport with constitutional norms and certainly to comport with our statute's requirement of the least restrictive alternative. And so we haven't, frankly, done much or enough litigation around conditions of release. And I'll tell you that the times that we've prepared to file appeals or whatever on release conditions, the court has changed them. So we've kind of gotten mooted out of those issues. We are anticipating in the next month or so some data on the impact of the racial bias impact of this new tool. And I think there's lots of litigation that's going to flow from that. New Jersey has a long tradition. After McCleskey came out at the US Supreme Court, New Jersey said that wouldn't work in New Jersey. If there were evidence of racial discrimination, our capital scheme would have been struck down, even though the US Supreme Court was comfortable with, just a wee bit of racial discrimination in the administration of capital punishment in Georgia. And so we think there are opportunities to litigate around the risk assessment instrument here. And there's also lots to be done on speedy trial. I'm working on an appeal right now dealing with what is excludable time. How do we ensure that the speedy trial protections that are also part of our new statute are really meaningful and that people are moving from arrest to trial in an expeditious way, particularly when they're locked up. So those are some of the things that we anticipate coming in the future. And listen, I know this isn't a webinar where we're supposed to talk about the New Jersey experience. It's more about litigation, but I just do want to point out by way of bragging that things are looking really good. And so when we started this project, we had about 9,000 non-sentenced pretrial detainees in our jail. And that number is under 5,000 at latest count. And so my view, and I'm sure others on this call, is that that's not nearly enough. That's probably 4,992 too many people, or some number too many. It's certainly too many, but it's also 4,000 people who are home with their families, for whom we could have had the same photo essay that Katherine showed for Mr. Humphrey, and that is really impactful and something that we're really proud of. So I think we're going to take some questions. Again, here's my contact information if folks have questions after this party ends, but thanks.
Wonderful, thank you. I want to actually just pose a question because obviously you all both work for kind of systemic litigation shops. And I think that public defenders have a key role because most often that is who is representing the people in the hearings, either after you get the reform or before. And so I wanted to talk a little bit about the role of public defense. And actually, Katherine, I wanted to go back to you for a moment and see if you could talk to us a little more about the program you had with the Public Defender's Office to bring habeas cases in San Francisco before you kind of took and ran with the Humphrey case. How did that get constructed? Is that a model you're using elsewhere? Is it a model you think others should be using?
So yes, absolutely. I think it's a model that that is extremely effective and that public defenders all over the country could be doing, should be doing, and that we are currently trying to replicate in other states. How it worked in San Francisco, how it came together was really just, it was driven by the fact that San Francisco has a dedicated bail unit in their public defender's office. And this is an issue that that the public defender, Jeff Adachi, was really interested in. So the fact that we had this strong interest and this resource of the bail unit really allowed us to go forward with it. Public defenders are certainly on the front line of this, and it's hard for public defenders, who are extremely busy, to add on this, all the work that goes into, especially the investigation that filing a strong bail motion requires. So I think San Francisco was kind of a unique scenario. Unfortunately, it would be wonderful if public defenders' offices all around the country had this bail unit that goes and interviews people pretty much right after they're arrested and is able to get contact information for their family and their employers, and is able to use that information to make a really strong motion for bail reduction or release on own recognizance. But since we had that in San Francisco, it really made sense for us to start this habeas project there, where there were so many people who could put the resources into it. And it's hard to first make that bail motion and then to draft the habeas petition, which is why we were able to provide that resource of drafting the petitions and that side of things. But it really was an incredibly successful effort. Humphrey was the result of a lot of petitions that were filed before, and in the earlier petitions, the Attorney General's office, who was defending against the habeas petitions, was always opposing them. And then actually in Mr. Humphrey's case, they announced that they would no longer defend any case where the judge had not considered ability to pay when setting bail, which was a really huge and exciting step. But yeah, I know it's a challenge to make really effective bail motions and to really fight this issue, but it's just so important. It has, such a huge effect on the case to have the arrestee be out pretrial. The research shows just huge differences in outcome for people who are detained pretrial versus released pretrial. And so I think it's, even though it's resource intensive, I think it's worth it for public defender offices all over the country to really be putting resources into getting people out pretrial.
Yeah, I mean, in New Jersey, we've also seen like the huge impact that it has when the public defender commits resources to litigating pretrial issues. And it both has a huge impact on the litigation around pretrial, but also has a huge impact on their overall work. I mean, the PDs that I've been talking to, we all know how much easier a job the prosecutor had in getting your clients, even your innocent clients, to plead guilty if they had pretrial detention hanging over their head. And so it's not to say that the coercive effect of pretrial detention is gone, but if you can narrow the number of people who are subject to that coercive effect, you improve results all around.
And are public defenders in New Jersey helping you to identify some of those cases that you talked a lot about that are kind of designed to make that statute meaningful, to identify where the weak points might be?
Not only are they identifying them, they're litigating the host of them. I've appeared as amicus in all, I think it's 8, it might be 9 cases that the New Jersey Supreme Court has heard. I think 6 of them, maybe it was 5, were public defender cases. And so there are a couple folks in their appellate section who have just been working kind of consistently from before the inception of the statute straight through in this kind of expanding and protecting. And when questions come up from trial public defenders, I'm talking to them, and the appellate public defenders are talking to them. And as I said, there's this organizational commitment from the statewide public defender's office of, this is a good use of your resources. We're not going to say, don't spend time fighting pretrial detention, because we understand that when you fight pretrial detention, what you're really doing is fighting the ultimate incarceration of your client.
That's wonderful. In post-reform jurisdictions, you can end up seeing a number of things that lead to backlash, whether that increases in failure to appear and the argument that it's costing the system in terms of efficiency and money, or bad case publicity where one person who was released does something terrible and there's a move to undo all of the reform. Can you each address you know, how you responded to some of that in the jurisdictions, you know, that Civil Rights Corps has worked, or I know I've seen some of that in New Jersey and the complaints about it. So.
Sure. I'll go first, I guess. So everything that you said is true, which is to say, well, let's start with the bad case, because it's not a question of if, it's a question of when, right? That someone on pretrial release will commit a horrible crime, and then there will be naysayers, mostly naysayers who have financial incentives to keep the old system in place, who will say, see, it's because you let all these people out. And I think the first thing we need to do is call bullshit when that's what it is. And so to point out that under systems of money bail, where lots of poor people are detained simply because they don't have the means to get out, there are also people who are able to get out, buy their way out, and then go on to commit other crimes. And so part of it is kind of trading anecdotes. And just saying that this idea that there will be failures on pretrial release is not new to a system that excludes money bail. It's true in all systems. And the only way we could really ensure there was no crime from people on pretrial release was eliminating all pretrial release. And that clearly is both bad policy and unconstitutional. And so the question is, how do we minimize that? So that being said, you have to be prepared, and all the stakeholders need to be prepared. It can't just be the defenders. The prosecutors need to be prepared to not throw the system under the bus when there's a failure. And so we've been really lucky that when there have been these horrible things that have happened, people have blamed the defendant, people have blamed maybe the decision-making in the particular case, but no one other than the bail bond industry has blamed the system for what's happening. With that said, you talked also about kind of other things that we need to anticipate. And one of them is that there might be an increase in FTA rates or in crime. So let me first confess by way of apology/anger that we don't have robust data in New Jersey on FTA rates or on crime rates as related to recidivism rates for people on pretrial release. We've been promised it. There have been these data problems that keep slowing it down. We were expecting it in January. I think today's the last day of January. I think we're probably a couple months away still. And they're legitimate data problems, but it's still really frustrating because I know folks in other states are looking to New Jersey, and the bail bond industry is saying, hey, the reason they're not turning this data over is because no one is showing up into court and everyone is committing new crimes, and it's like the purge. They've actually used that expression. The answer is, well, we know that's not true anecdotally. We know that's not true from talking to judges and prosecutors and defenders. And we also know that's not true because we've looked at the crime data. And so we saw that crime data for 2018 showed dramatic reductions over 2016. And it's not the finalized data, but homicides are down double digits. And we know there are also lots of reasons that happens. And I'm not suggesting that bail reform has dropped crime in New Jersey, but what it shows is it hasn't led to a spike in crime either. But it's a real question, and it's a fair question, because there are these kind of lots of forces that impact crime rates, and it would be a real shame if forces beyond our control led people to the conclusion that bail reform was bad for public safety. So we're really grateful that in New Jersey we have some counter evidence, but if another jurisdiction enacts reforms 5 years from now, and there are other trends that push crime up, you're going to get that pushback. And so it's important to have sufficient buy-in that people aren't in it for the short term. They're not looking at blips in the screen and saying, okay, we're out. We need a real commitment to say, we're going to do this, and we're going to test it, and we're going to spend some real time with the data. And if it doesn't work, we'll revisit it, but we're not going to let the first bad case or the first negative crime report say we're out and we're going to something else.
Yeah, I think that was great. And just to add that I think it's really important, particularly regarding the FTA rate, to put that in context for people so that people understand that, an increase in the FTA rate doesn't mean that all these people charged with crimes are fleeing to Ecuador, that the FTA rate is almost entirely made up of people who forgot to go to court or were unable to go for some reason. And that is a problem that we can address that doesn't, have to have anything to do with money, that there are much more effective ways to get people to court than just requiring money bail, especially given that most people who are able to be released on money bail get out through a bail bondsman and have paid a non-refundable fee. So the money isn't even operating as any kind of incentive in those cases. But research shows that there are much more effective ways to get people to court, and that can be something as simple as a text message reminder before your court date, or it can be rides to court for people who don't have transportation, or courts providing childcare for people who aren't able to, find someone to care for their children and miss a court date for that reason. So yeah, I think it's just really important to keep in mind that FTA rates are really not about flight, and that there's a lot we can be doing other than money bail that's significantly more effective to make sure people are coming to their court dates.
Great, thank you both. Another question from the audience has to do with what really amounts to variations in application. We have all seen this. If you've ever been in criminal courthouse, you've seen this, where what happens in one courtroom and the way something happens is very different than what might happen in the courtroom next door. The particular question here is whether Alex can address the variations in release and detention data between counties in New Jersey, kind of in the aftermath of the new standard, because at least it looks like from what this person's observing, that while monetary conditions seem to have gone away, there's a lot of variation in decision making. I think that continues to be true, and there's a little bit of a balance between wanting judges to have freedom, but also wanting to make sure that people are able to get out. So can each of you address that?
Yeah, it's a terrific question and an important one that we've been thinking about. And until we get this most robust data, I'm going to have to fake it a little, but I have some answers, and I hope to have more in a couple months. And so, first of all, you're going to have disparities between judges in the same county, right? And that's true also in the setting of money bail. When I was a public defender, there were the judges you knew you were going to get, six-figure bails on drug cases. And there were also the judges you knew you would have a shot at convincing to, ROR a client on a drug case. And so that's the first thing, is that the idea of disparities wasn't started with this new system. It's existed for a long time. In New Jersey, we get to see the county disparities, both in terms of detention rates and in terms of different conditions of release, whether it's how many people are having to call in to a pretrial services agency, to how many people are having to be subjected to home detention and GPS monitoring. And so let me talk about detention first, because that's the one where I think I have kind of the best answer. Police officers in New Jersey have two choices. They can arrest people on summonses or on warrants. A summons is a traditional, hey, show up in court on February 15th, and that's it. No conditions, no anything. And in a warrant, you'd go through this whole risk assessment process, and you'd be released on some level of conditions, from ROR to kind of onerous conditions like a GPS monitor. In some counties, we've seen really high detention rates, alarmingly high detention rates. And when we started digging to figure out what was going on, and almost no one getting ROR'd, and almost no one getting kind of the most minimal of conditions. When we did some digging, what we realized was that police officers were running risk assessments, and people who were going to get ROR'd or released on low-level conditions, they were simply charging on summonses. They were cutting them out, both of the numerator and the denominator, in the question of how many people are detained. So when you saw that they were moving for detention in 80% of cases, I mean, first of all, that's gross no matter what. But it wasn't quite as gross, because what they had done is they had kind of made this front-end decision, say, we're not even going to charge the person on a warrant if we don't think that they're worthy of detention. Now, judges have luckily stood as a bulwark and said, great, thanks for doing that first screen for us, but we're going to make another screen, and we're going to deny detention in lots of cases. But you get the same thing when you look at conditions cases, which is we had kind of predictions of how many people were going to be ROR'd, how many people were going to have to call in once a month, how many people, and we have fewer people getting ROR'd. And I think the reason for that is because those people are being released on summonses instead. But the disparity is something that we need to tackle. And look, we have a lot of experience in New Jersey with litigating around inter-county disparities, and we have a lot of experience in it really backfiring on defenders. So when we found out, this is now 15 years ago or so, it's actually longer than that, but when we found out that defendants, there's a mandatory minimum for selling drugs within 1,000 feet of a school, and defendants in rural counties were being held to those mandatory minimums, whereas because of volume, in urban counties like in Essex County, the mandatory minimums were being routinely waived. And a defendant in a rural county said, hey, this is unfair, I'm getting treated worse because I'm in the rural county. And the court said, you're right. And the solution wasn't to start waiving the mandatory minimums for the folks in the rural counties, it was to start imposing the mandatory minimums on folks in the urban counties. So we want to make sure that as we seek to have uniformity amongst counties, it's not uniformly denying people ROR, uniformly imposing harsh conditions, but that it's uniformly ratcheting down conditions rather than ratcheting them up.
Katherine, did you want to add anything to that?
No, I don't have anything to add there.
Okay. So the next question concerns, and I actually see this a lot in criminal justice, where sometimes the easiest systems to reform are not the worst systems. They're kind of the moderate systems, because at least you have some apparatus for finding out what's going on. There are people in the courtroom. There was a question sent in by a public defender in Pennsylvania who asked, how do you even start bail reform in a system where the initial bail is set, not on the record, and not with a public defender in the room? So you have really no idea the basis for the decision or a basis for challenge. What would you recommend in that situation? Katherine,
do you want to go first, Katherine?
Yeah, I mean, I'm very aware that that is the system in a lot of jurisdictions all over the country, and it certainly does make it difficult. You know, reforming the system in that situation, you know, might even require like starting out with some sort of, you know, lawsuit or some other, you know, mechanism to, you know, try to force, you know, open court hearings in those situations. But, you know, I don't think it's impossible, even absent that, to challenge the system. You know, I'm not saying you have to, you know, sue to see the bail hearings. I think, you know, in a lot of cases, there's a hearing, there's a subsequent hearing, and you're gonna maybe just have to try your best at that hearing to, you know, change the system and advocate for that hearing to be, you know, a more meaningful opportunity to advocate for a client's release, you know, to push for bail motions to be heard as soon as possible, to push to represent people as soon as possible. And, you know, it doesn't have to come through a lawsuit either. There's certainly a lot, I think, of advocacy that can be done behind the scenes to say, you know, at the very least, you know, you need to be having open court hearings, or, hey, you know, we think it's important that people be represented at that initial appearance. So can we work on trying to find some way to, you know, have public defenders there at that initial appearance? That was one of the important changes that came out of the Harris County litigation. You know, as I said, when we brought the case, there were no public defenders at the bail hearings. They were on the record in that, you know, we were able to watch videos of past bail hearings, but there were no public defenders there. And one of the things we focused on in the litigation was that needs to be an actual adversarial hearing, that first bail setting. And the county agreed to allow the public defender to be at that hearing and to represent almost everyone at that hearing, which, you know, was an important development. And, you know, I think it's possible to get that kind of change to happen, even without, you know, this major lawsuit hanging over the county's head. It certainly helps to have that there, but yeah, I think it just requires some advocacy to get those hearings open and to have people represented at that hearing.
Yeah, I'll just add that Katherine's totally right. It's a necessary precondition to meaning, and the question is right in its premise, right? To get meaningful change, you need to know what you need to change. But you can get that first step, the data collection, let's call it, through openness or whatever. You can do that through litigation. You can do that by a court rule, right? So we've talked to lots of, you know, chief justices around the country who say, we want to bring about bail reform, we don't know how to do it. So get those folks to say, as a very first step, we're going to bring these decisions out of the darkness and into the light and allow scrutiny of them. It could be through legislation. So if you can't convince your legislature that they need to do a comprehensive bail reform, at least say, let's measure it so we can understand where we are, where the problems are. And so it's absolutely true that you can't do any of this if you don't know how things are happening. You can't measure disparities, you can't do anything.
Good. I'm just going to add to that there has been a wide growth in court observation projects that are really kind of citizen efforts to shine light on what's going on in some of these darker places in our criminal justice system, some of the places that a lot of people don't go and sit. The section on civil rights, social justice did a misdemeanor observation project in Nashville that spurred similar work that I'm involved in both New Mexico and Florida. And I think that's exactly what it's doing. It's going into some of the no counsel courts and saying, what is happening here? And bringing in kind of an outside eye to look at it. So, I mean, I don't think these courtrooms are closed. I've been to some of the courts in Pennsylvania where bail is set, and they're just not lawyered courts, and they're not judge courts, right? They're all, a lot of the magistrates or whatever they're called now, they've changed names several times, are actually like ex-police officers. And it's all prosecuted by cops, but you can go sit there. And I think one of the things is to actually just kind of find a person who can go sit there and make the information known about what exactly is happening. I want to try and get back to some of the questions that have come in. I actually don't know the answer to this one at all, but if either of you have followed the reforms in Connecticut and have any comment on them, there was a question about our take on the Connecticut reforms, which ex-Governor Malloy has touted as perhaps his greatest achievement. Is that something either of you have followed?
Hasn't been on my radar.
No, unfortunately, not mine either.
Me either. All right. Then I want to ask another question about, Alex, you were talking about presumption of release as kind of a linchpin, I think, in the bail reform movement. And Katherine, you kind of mentioned two different standards, but at its heart, presumption of release is kind of the cornerstone. And Alex, you were talking about the kind of interaction with risk assessment. Katherine, do you have anything from the national perspective on the interactions of kind of the rise of new and more sophisticated risk assessment tools with this presumption of release?
Before Katherine goes, can I just say one thing to kind of contextualize my comment, which is, for a lot of reasons, New Jersey was in a different place. We had a Chief Justice who was really committed in a way that I believed to a vision of pretrial justice reform that was release and liberty focused. And so there were certain decisions made in the legislative process to vest the courts with more discretion than I think I would in other places. So if I were looking at how to create a model system in another place and I didn't have that same faith in the judiciary, I don't think New Jersey is a model in a lot of ways. And I don't think that presumptions are the solution to deal with a net that's too wide or risk assessments that are so dangerous and discriminatory in place. So in New Jersey, for example, we've seen judges going against risk assessments that are recommending detention on a pretty routine basis. If you don't have that sort of confidence in your judiciary, I don't think presumptions or anything are the solution. I think the only way to do it is to narrow the net of folks who are going to be detained. Because I think in most places, if you authorize judges to detain, they will find justification either on their own or through risk assessment tools to justify that detention. And so we've been successful in New Jersey in not having that happen, but I wouldn't call it the linchpin. I wouldn't call presumptions the linchpin to a good system. They've been what's prevented New Jersey from becoming a terrible system despite a net that's too wide. Anyway, so.
No, that was very helpful. Thank you. So the question of risk assessment tools is certainly worthy of its own webinar probably, but just to give a few thoughts. The main problem with how risk assessment tools are currently being used is that judges are using them to make the decision of whether a person should be released or detained, which is just not how they should be used. The risk assessment tools, are a potentially useful tool in terms of helping judges decide, what conditions of release to impose on a person. If it says someone's at high risk of failure to appear, that means that if you, provide no services to this person whatsoever, it's likely that they are not going to show up to their next court date. And what a judge should do with that information is say, okay, then I'm going to, require text message reminders. I'm going to require you to check in on a weekly basis with pretrial services, or, in an extreme situation, like I'm going to require an ankle monitor. These tools shouldn't be the basis for that, crucial decision of whether the person should be detained or not detained. And unfortunately, that is how judges across the country in jurisdictions that use these risk assessment tools are using them. And it's especially concerning because the tools, there's the sense that they're scientific, but in fact, the outcomes are very much political. A risk assessment tool might spit out a number 1 through 7. But what does that number mean? It's usually up to the judges or, potentially the DA or some other decision makers to decide what a particular number means and what constitutes high risk versus low risk. So these tools, have this imprimatur of like being scientific, and people aren't considering how political, in fact, they are. And so, I think the real key in any state is the detention net. In California, this new bail legislation, SB 10, creates these tiers of people arrestees based on their risk assessment score. If the score says you're low risk, then you can be released. If you're high risk, then there's a presumption that you won't be released. And if you're medium risk, you'll see a judge and you might be released, you might not. And that's very concerning. And I think the only way to really undo the potential damage of SB 10, in terms of these risk assessment scores is, for the Supreme Court to say that the California Constitution only allows for detention in a certain limited number of cases. And it doesn't allow for detention simply because this risk assessment tool, said that a person was high risk based on a category that was defined by judges and prosecutors. So I think risk assessment tools need to be used very carefully and can't be the basis for a detention decision, and that really the only way to make sure that pretrial detention is carefully limited, as the Supreme Court has said it should be in Salerno, is to make sure the detention net is very small, and that as few people as possible are allowed to be detained pretrial.
Thank you, Katherine. Thank you. I want to kind of start to wrap us up. And so I'm very grateful to both of you, but I wanted to give you each the opportunity to talk about the future of bail reform, where you think we are headed with this, either in the near term or the long term. Alex, you want to go first? Sure.
So I don't know. I mean, the bottom line answer, I think Katherine's right to reference Salerno. Salerno was a kind of major loss in a lot of ways for people who care about liberty, because it codified this idea of pretrial detention. But in it, we find the basis for all of our work here, which is that liberty is the norm and that detention prior to trial has got to be the carefully limited exception. And so it's fine to do it legislatively like we did in New Jersey, to do it through litigation, but it has to happen everywhere. Jurisdictions that aren't treating liberty as the norm are not abiding by the Constitution. And so there's going to be a lot of resistance to change in jurisdictions, but it's coming. It has to come, because we know how devastating pretrial detention can be, both to people's lives when they're separated from their families and their homes and their housing and their health care, but also to their criminal cases. And so defenders are getting behind this because they recognize that the more they want to win, ultimately, the more they need to be getting their clients out in the first instance. So I think the answer to where do we go from here is to look back to the 80s, to Salerno, and make sure that liberty is the norm everywhere.
Wow, hard to compete with that mask, but I'll try. So, I think the next step really needs to be a change in the culture around how bail is set. Just in most courtrooms around the country, judges are just not putting the level of thought into this, crucial decision for arrestees that they should be, and that bail hearings are these quick proceedings where the judge, chooses a number off a schedule or, makes up a number, and never actually seriously considers whether the person needs to be detained, what other conditions could be imposed other than money, where unfortunately there's just not a lot of information being shared about the person's life and the circumstances and the support that exists for that person. And it's hard to change culture, and we've certainly seen in California, even after this incredible ruling that applied to every single courtroom across the entire state came out with Humphrey, that you know, a lot of people are getting out now who maybe wouldn't have before Humphrey, but a lot of people are still in jail who shouldn't be, and a lot of courts aren't doing what they are supposed to do. And so, you know, victories in court aren't enough. We know that. And it's going to require this cultural change. And I think a lot of that has to come from public defenders really advocating for their clients and defense attorneys in general, of course. But also, there are other really exciting things going on. I especially want to flag the pictures that I showed earlier were from this organization, Silicon Valley Debug, that's doing really incredible work on participatory defense, which is a really cool you know, thing where the community is getting involved in bail setting. And you know, they show up to court with they meet with the public defender before the bail hearing to, you know, give a full picture of the arrestee's life, you know, and show up to court with the arrestee's family and employer and friends, and show the court that, you know, this is a member of the community who has support, and it's, you know, a person who can be released safely. And so efforts like that, I think, are really exciting. They also do court watching, and you know, I think that's another important thing. I was recently down in Harris County watching bail hearings, and the judge gave almost everyone a personal recognizance bond and released them. And afterwards, the public defender said to me, you know, this judge almost never lets all these people out. I think it's because you were here watching. So, you know, it's, you know, court watching can be an important part of it too. Yeah, just shedding a light on this extremely important moment in a criminal case, and making judges care about it and take it seriously, make it into a real event in the defense process. I think that's the next step to really ensure that the victories that we've had in court and legislatively all around the country actually, you know, meaningfully change things for people arrested with crimes in this country.
Wonderful. Well, I just want to thank our panelists one more time and thank their organizations for the wonderful work that they're doing. And I want to remind the attendees to make sure that they check out the wonderful materials that were provided under handouts. There are a number of briefs that are there in addition to Alex's PowerPoint, and I encourage you to take a look at those. And finally, I want to thank the ABA section on civil rights and social justice, and particularly Paula Shapiro, for running this for us. Thank you very much. And we will be back with other topics soon, and hope you will join us again.